was just never explained. And here the statistics are actually very, very crucial. If I could ask the court to look at paragraph 16.2 of our note, we say that counsel for Nadel argued that the top 6% as a proportion of the total number of attendee firms, just 0.1%, had a disproportionate significance for transformation. However, the LPC's 2024 statistics on the number of attendees is also instructive. They indicate that over 33,000 practicing attorneys, associated partners in South Africa, only 1,295 are employed in the top 6. That's the question the Leadership Presiding asked. Of those, approximately 700 were black, that is over 50%. Now, these are people that are unfortunately tarred with the brush of resistance to transformation. And these points, resistance to transformation, are just not in the record. Every young advocate that comes at the bar is taught one of the basic lessons: never make submissions from the bar that are unrelated to the pleadings. You've been treated to a lot of that in the last 2.5 days. We also took the court to the DTIC minister's affidavit, where the minister disclosed that the legal sector generates approximately 30 billion per annum, and that a substantial portion of that sum is generated by firms other than the top 6. And that's why I made a maximum of 10 billion to show that there's the 20 billion that should also be subjected to economic regulation under the legal sector code. And in paragraph 16.3, the LPC's own statistics show that the unregulated part of the sector are less transformed than the applicant firms. They've given us the numbers, 1,200 in total, 700 are black. And then we said the record evidence is that these facts and the implications of regulating only 5% of law firms were not even considered by the minister or the LPC. No reasons are apparent in the record for the exclusion of the vast majority of lawyers. And it doesn't help for our learned friends to repeatedly say, well, no one is excluded, everyone is regulated. What they need to show, as counsel for Nadel correctly pointed out, are also subjected to the scorecard. And the scorecard may be flexible in relation to the size, but they are subjected to the scorecard. Of Justice provided new ex post facto justifications, saying that regulating small firms in this way would be counterproductive, etc. Well, that may be the case. But the point is that ex post facto justifications do not. We say that the respondents failed to address the absence of reasons for the other critical exclusions, the removal of student bursaries from the skills development scorecard. And certainly we feel strongly about this. I'm going to talk about it in a second, but let me just list these exclusions that are just wholly unjustified. The removal of vocational training of less than 1 month, the removal of skills development for black employees with disabilities, and the exclusion of the entire socio-economic scorecard. When you look at all of these exclusions cumulatively, you are bound to the inevitable conclusion that transformation is just a word for the respondents, because in substance, these are retrogressive measures. And the GCB don't need to complain about student bursaries because the problem is not entry but retention. But this is not a justification that is apparent from the record. But there is a bigger problem that the GCB omits to take into consideration. Why is there no problem at entry? It's because bursaries are available. Because they have contributed to the increase in the number of black students, class backgrounds that are talented but have no access to legal education, and they do not qualify under the NFSAS program. So closing that tap by removing the incentives simply reduces even that pipeline of entry. I mean, this is just arbitrary. What were they thinking when they were drafting this code? The exclusions from the skills development scorecard and the removal of the socio-economic scorecard, together with the exclusion of 95% of the sector from the code and the removal of black non-lawyers from the management control, are reviewable, we say, also for the breach of Section 9.2 of the Constitution. So none of these arguments, they were very, very interesting policy proposals. But the core of the arguments that were made, that the record does not provide justification for this, has simply not been answered. Let me move then to topic number 2, which is the role of the minister of the DTIC. The counsel for the minister has described his client as a midwife who is responsible of the baby. But we say that is where the misconception actually begins. What he doesn't appreciate is that the minister is not responsible of the code, but he is responsible for the code. And that means that the minister himself must be satisfied that the code is lawful, it is rational, and it complies with the minister's own regulatory requirements, such as Statement 003. And we say the scheme of the Act supports this interpretation because the Act requires multiple steps in the development of the code. Only 2 sections are necessary to emphasize. Section 9.5 that gives the power of the minister to publish the code and section publication to pass the code. Why would that be necessary if the minister's role is only midwifery? Paragraph 23, I'm not going to read that for the record, but we say that the predecessor seems to have had a better appreciation of the statutory function of the minister.
Not perform a tick box exercise.
Precisely. Thank you. Then the third point is around the BEE strategy. Now, I began my argument by saying the BEE Act is a product of the Constitution. Compliance with it is compliance with the Constitution, not violation of Section 1C of the Constitution. We say, as Mr. Baum pointed out, that there is a dispute among the respondents about whether the strategy exists or does not exist. The Minister for DTIC says it exists, although it pre-existed the Act, but the Justice Minister said it does not exist. Now, just on that conflict between the 2 ministers, who are both members of Cabinet, these 2 ministers, one is a critical stakeholder in the development of the code, the other is a critical stakeholder in the publication of the code. But they seem to have worked on fundamentally diametrically opposed premises. Now, you are looking for arbitrariness, but here is arbitrariness staring you in the face. Now, if you assume that the strategy exists, our point is simple. There was no consideration of that strategy.
I think I did ask the question where does one find reference or we can see that the strategy was considered or applied.
Yes, well, according to the Justice Minister, you would not find it because the strategy doesn't exist. According to the DTIC Minister, you will find it, but you remember where they referred us to. They referred us to the website of the DTIC, not to the record. So the question, therefore, is what is the legal effect of Section 9.2 and 11.2 of the BEE Act? Now, that turns on the peremptory language used in those sections. We've cited the case of Capitec, which follows Endumeni, which says interpretation begins with the text and the structure. They have a gravitational pull that is important. The proposition that context is everything is not a license to contend for meanings unmoored from the text and the structure. Rather, context and purpose may be used to elucidate the text. My ladies, I have read many judgments on interpretation, and I have no doubt the court has read even more than I have done. There is not a judgment that says you can ignore the language. And that's what Mr. Badlander once argued a case in reply, and he said the court has been tactical. So, and the consequences for non-compliance with Section 9.2 ought to be clear. The minister did not comply with the Act. When you have not complied with the Act, the consequence is invalidity. And there is no debate here that, well, the minister substantially complied with the Act, because the minister did not even plead any substantial compliance. So we have a clear-cut case of a violation of the Act. Now, the consequence of that is that the decision is invalid from the beginning. The third point is the legal effect of Statement 003, Mr. Butt of the heavy lifting on this case. But I want to just introduce one more consideration, which is paragraph 30. In the case of AMCO, her ladyship presiding will be familiar with this case. The court dealt with whether guidelines issued by the Minister of Labour under Section 8 of the Labour Relations Act were binding. The court found that those guidelines contained mandatory language. They used the phrase must, that as a result they were binding. And as the court stated in that case, there is nothing ambiguous in the word must in the context of the guidelines as a whole. Call it to Statement 003. And again,
was it taken on appeal or not? Don't we know?
This is a 2021 judgment, so if it was taken on appeal, we would have known by now. Yes. But your leadership actually did not make any revolutionary findings there that would attract the attention of an appeal court, because your leadership applied trite legal principles. If you go to statute, in the same section, section 9, one part of the section says must, another part of the section says may. What does that mean? Old law. It means that the legislature intentionally wanted different interpretations to those phrases. In fact, the counsel who acted for the Minister of Justice accepted that there must be compliance with the requirements of Statement 003. Justice Passon asked counsel for the Minister, why must there be compliance with the requirements for deviations in the guidelines? The reply was, for consistency and rationality. We agree. Then that takes me to my final point, which now that was addressed today by Mr. Jurens, who spoke a lot outside of the record. The declaration of law under Section 172(1)(a) of the discretionary. If you find a constitutional defect, you must declare the law or conduct unconstitutional. And that comes to paragraph 3 of our notice of motion, the declaration of invalidity. The question is, what happens thereafter? Now, ordinarily, a respondent might come to you and say, sorry, this is a very important instrument and you're going to cause disruption if your declaration of invalidity. That's the only time at which 2 comes into operation, 172(1)(b) comes into operation, declaration of invalidity, where the declaration itself is mandatory. But what happens in those circumstances? The case law is clear. We've cited it in paragraph 36. At the hearing of this matter, the municipality urged this court to suspend the declaration of invalidity for a period of time, contending that it is just and equitable to do so. But it could not point to any facts on the record which warrant suspension of the order. Number of decisions, this court has stated that suspension is not there for the asking. A party that seeks to have an order of invalidity suspended must place on record facts justifying suspension. So here, the only party that could have done this job for us is the minister. He could have said, I don't want this to come into operation immediately. These are the reasons. What you cannot have on day 5 of the argument, somebody standing up and saying, no, this is very important because it has set up the Charter Council. That's simply not how the law works. And then you also were treated into another spectacle of severance. But the reason is because it's not borne out by the record. So what you are ultimately left with, my lady, you are left with no answer to the substantive case, no answer to the rationality case, no answer to the legality case, no answer to the remedy. And therefore the case is actually as straightforward. You didn't deserve the spectacle. As you please, my lady.
Thank you, Mr. Mphatheli. Wil julle so 10-minute breekie vat of nie?
Nee, ons moet klaar.
I've been asked whether your leadership want copies, but I thought you found it in the...
We did.
Yes, thank you. Then I can keep this copy.
Thank you. Yes, Mr. Becker.
There was just a quick discussion that the committee was going to have before I replied. We can just maybe take 5 minutes or 10 minutes, if you do not mind. And then we'll try to do as quick as possible.
5 minutes.
5 minutes, perfect. Court will adjourn for 5 minutes. Thank you, Mr. Becker. Last but not the least.
I will really attempt to be brief. It is Friday, it's been a long 5 days. My learned colleagues for the applicants in the what's called the Northern Rose and other, the nice matter, dealt with the bulk of the issues that were also raised by Solidarity in its self-standing application. And I'm saying self-standing because Norton's here. Equally, as per the application in the Denise matter for the second to further applicant, also seeks a declaration of constitutional invalidity. Case lines 01-2, that's prayer 2 of the notice. And I'm not going to repeat what my learned colleague has just stated. It's not necessary, but I just want to draw your ladyship's attention there too. Furthermore, our matter consolidated, as you are all aware, it was agreed simultaneously, and that one judgment will then be authored in
one judgment.
The court's discretion, yes, as per the various meetings between the parties and the court, acting DJP, etc. But let me then start by saying I really didn't want to do this, but I'm compelled to address the issue of locus standi again, it appears. I was hopeful when the leadership said that move on to the facts of the matter, that it may have disposed of that, but I will really attempt to be brief on that, saying that there's no basis in the attack on locus standi, but I need to address that. Then there would be a short discussion of the respondents' reliance on transformation in the abstract, instead of focusing on the legal issues at hand. Now, Mr. Natobi indicated that he is yet to hear the case of the respondents on the record, on the pleadings and the law.
They had to meet on the papers.
Yes, and read with the Rule 53 record. Yes, it is so. Much helpful submissions were made, sometimes a bit emotive and politically loaded, but that is the we're dealing with here. No one said this was going to be easy. No one said that there is no need for transformation. It's how it is done and how it was done in the current fashion in the legal sector code. So that is the question. And emotive and political statements, this is not Parliament, and I'm saying that in jest. This is the courtroom. We should respect the court, and we should deal with the facts, and then the law must be applied. So what are those facts? Those are the facts in the pleadings of all the parties, but especially the first respondent minister. Here's the important factor. You must tell us how the scene was set and how it happened that this piece, this legal sector code, was adopted and published. Then I'll quickly deal with the point taken by Solidarity on Section 5 of the B-BBEE Act. The whole issue of the Advisory Council, not much was said by the relevant respondents. I'm saying the relevant, the first respondent naturally, and the second and third on this point, but I just need to stress the importance of this. And lastly, I will deal with the composition of the committees, the review standard, and the relief. And I must state that is the Solidarity's written submissions would find case lines 18-1 to 18-99. Well, that luckily includes authorities, otherwise it's only naturally a separate case line file for the Solidarity
so it's
matter.
18.
Yes, madam. Section 18, page 1 to page 95, excluding the list of authorities. But, Ladyship, I've referred to that in the opening address as well. I'm just saying that I'm not going to go through that. Some of the issues I really didn't at length because it's all in the written submissions. And we even heard one of my learned colleagues saying, but the whole issue of the Section 5 argument is not on the papers, and it is. It's paragraphs 22 and 23 of the supplementaries. So it is unfortunately to properly then peruse the pleadings of Solidarity and especially the first respondents answering that self-standing application. And you would note that plus minus 50% of the amendments made by Solidarity in both the founding and supplementary affidavits were not dealt with in any detail or at all by the Minister of the DTIC. In that self-standing application, to say I incorporate the amendments made in the Norton Rose application herein as is specifically repeated, is simply not sufficient. Those are two separate issues. There are distinct issues raised by Solidarity that was never entertained by the Minister. And we don't have to even talk about the principle applicable there in opposed motions. We all know the basis.
To be admitted.
Yes, Plascon, as some colleagues put it, the Plascon evidence rule, but I know it as the Plascon evidence rule. But it's, yeah, and that is what it is. So I'm not going to take that rule. So let me just move then to the issue of locus standi. Now, it was pleaded in the founding and clarified in the replying affidavits. Now, it was also said on what basis Solidarity is challenging this code. And all the bases were covered. Members, it was done in the public good, so to speak. It's all been canvassed. But now the issue is, but you're not lawyers.
You're a trade union.
But I had to dot that down, because is that really the argument? But it was the argument. The arguments, in essence, if you heard the argument, especially the first and the second and in the third respondents, that Solidarity must produce a list of attorneys and advocates who are members, failing which it should be non-suited. Now, the same may apply for the respondents in general, but no one asks, where is your membership list? And I wonder if Solidarity was a respondent, whether that would be an issue. I doubt it. There was an issue that
But one must also take into account that this is part of the legal...
The name says it all.
Yes.
Yes. But we can go through all the response, but we don't have time for that. The bottom line is, if there's only one member of a trade union that's being impacted, they have locus standi in here. The well-known judgment, I think it's Krookamp, Minister of Justice, Equality Court. I think Mr. Krookamp was a magistrate, Solidarity acted there on his behalf. There are numerous examples. Why is it necessary to go into that argument? How can a trade union operate in the legal fraternity? It is respectfully nonsensical, and it just serves to delay the finalization of this matter. But let me just address an issue on Section 38 of our Constitution. It says everyone listed in this section has the right to approach a competent court, alleging that any right in the Bill of Rights may have been infringed. And it then says in E, an association acting in the interest of its members, and C, anyone acting as a member or in the interest of a group or class of persons. It's been said in the founding affidavit, raised the issue, but the issue remains. Let me see if I can clarify that issue any further. All the parties here appear to be in agreement that this application may also be concerned with allegations that rights in the Bill of Rights may have been infringed or threatened. That is not in dispute, and there the standing arises. But the problem that we have with the argument of especially the Minister, well, and by the way, the Saripa judgment, the insolvency practitioners, Solidarity was the fourth applicant to court a quo, and the fourth respondent in the court that ultimately made the decision.
So it wasn't a problem?
No, it was no issue. No issue. As far as I can gather, Solidarity is not an insolvency practitioner. Well,
it's interesting, there was some reliance on that case.
Yes, extensively so. That wasn't an issue. But as soon as we get to the legal sector code, out the door you go. But it goes wider. In this submission of 30 August 2024 to Minister Tau, shortly after he took office and shortly before the code was then published, you will find out on case lines, Solidarity's case lines 08-3357, the LPC lists the feedback as received on the draft legal sector code, which was then in March 2021. It was a whole history. The feedback was described as being received by all stakeholders, legal practitioners, and interested parties. Stakeholders, 2 legal practitioners, 3 interested parties. We know they're not 2, not legal practitioners, but 1 definitely a stakeholder and definitely an interested party. And when the comments were requested by the steering committee, they said it's relevant to all procurers of legal services. Now, I have an attorney in court, and I'm sure his account will be paid by Solidarity, and I'm hopeful that he also has mercy. But in the end, it is a procurer also of legal services. I can't belabor that point any further. It is what it is. Now, Solidarity was in that list, was listed as a stakeholder, and a certain Mr. Dani Akker from the South Cape Solidarity Guild of Legal Practitioners submitted that, and he was listed on his name. There it appears. So you're an interested party, you are a stakeholder, but as soon as you come to court to say, but we have given our submissions and...
We've been part of the process.
Yes, but now we can't challenge this. But in any event, the Legal Practice Council's case lines 13-56 says, quote, Solidarity's representations were received, its views were considered, but not accepted. But this does not render the outcome arbitrary. It's not arbitrary, the outcome. Okay. But then even the LPC recognizes Solidarity as a stakeholder, or at the very least an interested party, but still they persist with the point. Now, just on a side note, Mr. Nalani for the debate that the Charter Council should have been joined. But that is in the Northern Rose or the Denays matter. That point wasn't taken in the Solidarity matter. So you can safely proceed from the premise that there's no non-joinder point pertaining to the Charter Council from the
So we
Minister.
can still deal with the merits.
Yes, we'll still deal with there was no point taken as the Minister has taken in the Northern Rose or Denays matter. Now, Mr. Nalani stated in argument for the Minister that the persons who are likely to be affected by the code are legal practitioners, and that they have every opportunity and will in fact present evidence in argument in this court when he opposed or advanced his locus standi argument. The question then needs to be asked, and this also goes to rationality and legality. This is the argument that was advanced. Why did the Minister not simply discard all the comments and suggestions received by other industry players, interested parties in the public at large, during the so-called consultation phase, if it's only the lawyers that matter, not the public? Why have regard to, why even read and engage with all those comments? And that is an important point. So Solidarity's case is simply, it latches on to the applicant's case, that there was no proper engagement with all these commentaries. Then there are no reasons given why these commentaries and suggestions or critics, all the critics and all the reasons they gave for it were properly assessed at the time. And at the time being the Rule 53 record and when this was adopted and published, not an ex post facto exposition of what may and what could and what is now. That is respectfully too late. So that is also quite peculiar. It now appears that the Minister is saying it's only legal practitioners who are affected, although the code appears to have been denigrated from applying to all procurers of legal services. It's quite telling, that argument, and I press your ladyships to take that into account. It clearly just shows the irrationality and lawfulness even of the sought to be impugned code. Now, let me move on to the next point. I still have a bit on the locus standi point, but I don't think I'm further. I have about 5 more pages, but I will just leave it at that. Just the last point, my lady, which I need to make on this. C, published. You will find that case lines 083155. The feedback, so to speak, on the process followed thus far under the heading Legal Provisions for Sector Code. Now, the following was stated. The generic codes of good practice is the blueprint for sector-specific codes. The development of sector codes is an integral and strategic vehicle to advance transformation in the economy at sectoral level. A sector code development process, is driven by the sector stakeholders, then in brackets, business, labour, community and government, led by the responsible line ministry. Now let's look at the comments. Labour. To look at all the comments received during the stakeholder engagement sessions and commentaries. It's only Solidarity. The only trade union. That's Labour. CSI is there, but as far as I know, CSI is no longer an employers' organisation, it's only an employers' association. So Labour, so use Solidarity to tell everyone that Labour has been consulted, but stakeholders have a role to play, and that is right. Why do you
Everyone needs to be heard.
we constantly have these preliminary arguments, this technical point taking? It's taking us nowhere, but I'll leave it at that. I've said in my opening address that whoever persists with this argument will ask costs, but costs should anyway, on the by-watch principle, follow the result. But should your ladyship decide not to review this code or not to include it unconstitutional, then we see costs on the issue of locus standi against the first to third respondents, jointly and severally. Transformation is not the issue. Now, the respondents repeatedly emphasize that transformation is non-negotiable. It's part of the constitutional DNA of our country. They also say that restitution measures are authorized by Section 9(2) of the Constitution. Solidarity didn't and doesn't contest any of that, nor did it in the current application. I may invite, and I say this in jest, the Council of SAWLA to carefully peruse Solidarity's papers and the amendments made in the heads. It did not contend, and it doesn't contend, that the state may not adopt measures to advance, persons' previously disadvantaged by unfair discrimination. It never said that. We heard emotive and political statements. It will not advance this case. It doesn't contend that the legal sector code can never be adopted. To suggest otherwise is just simply spurious. The issue is narrower and way more fundamental, being whether the legal sector code was lawfully adopted and rationally designed and issued in compliance with the statutory instrument, the B-BBEE Act, and Statement 003 and the Constitution. I'm not going to say much about Statement 003 and its impact. I think it's been extensively addressed by colleagues as well. But what I want to say is that a restitutionary measure or a measure doesn't become judicial scrutiny because it is now labeled transformative or restitution. Now, even the Saripa case dealt with such a matter. The Barnard case dealt with such a matter. All of those are important matters that must be addressed and must be debated. Now, the imperative constitutionally to transform is not a license to bypass reasonableness. It's not a defense to irrationality. The court is, in conclusion on this point, not asked to determine whether transformation is required, as argued by the respondents, it appears, mostly. It's asked to determine whether this code is defensible.
Do what judges should do.
Yes, my
Apply
lady.
the law.
And luckily, that is the judge's problem to decide on this. It is counsel's duty and the attorney's duty to present the facts and the law. Mr. Malani for the information is non-negotiable, and it is so. So let's step away from that. Let's go to the Gazette that has accompanied this section, this legal sector code. It was issued in terms of Section 9(1) of the Act. It says it's specifically the Gazette. That is the minister's power, and he is the one who exercised it, or had to exercise it. He was duty-bound to satisfy himself with the statutory preconditions, and if those were met. That was his duty. He had to apply his mind with not only the Act, also Statement 003, and then through the prism of the Constitution. The respondents cannot have it both ways. And I'm talking specifically to the first respondent here. As I say, valuable contributions have been made by all respondents, but it's the first respondent that we must focus on. It cannot be said that the minister is the lawful source of the code when defending its binding status, but then reduce him to a passive midwife when his application of the mind, so-called, is challenged. The minister was entitled to rely on his officials or on officials. That's not disputed. But in that reliance, it doesn't relieve him of the duty to understand the legal nature of the power that he was to effect and exercise and the statutory requirements governing it. It was argued that there was a fact sheet and well, that may assist the minister, but it doesn't cure non-compliance. Little, if any, reliance was placed on the record of this process by the respondents. Who, what, where, why, how? None. Well, very limited. Where's the strategy? We were advised during argument by the respondents it was discovered and it was now uploaded. Doesn't work like that. Where was it when the minister had to apply his mind? Where was that document that predated, apparently, I haven't seen it, predated the promulgation of the Act in 2003? Where was it? The argument further develops for Minister Tau that he came late into office during this process, received a briefing, a fact sheet, and a representation. And he was not required, and I quote, to be a subject matter expert. Well, you have advisors, you don't need to be a subject matter expert to apply your mind, and there, you can go to the subject matter experts. Who are they? The Advisory Council, the Presidential Advisory Council, Section 5 sub C of the Act. The experts, they are subject matter experts. If you don't know, ask. Or you should look at the empowering legislation and then say, you know what, technical committee, steering committee, or advisors, where is the advice of curated Presidential Advisory Council? I'm new to this, I'm fresh, so to speak. I'm not a subject matter expert. Let's ask and let's use what the Act provided us. Now, it's not an absolute defense. The point of solidarity was brushed aside by saying, yeah, you see, that section doesn't say the minister must advise of the Advisory Council. It says that the Advisory Council must provide advice. Now, if it's absent, you can tick. There's not a may, there's a must. The may comes in a bit later. Don't quote it's a discretion if it's not. Because if you properly analyze the wording of the Act, I'm not going to say anything about the wording, and I think enough has been said about that. Functions of the Council, 5C. The Council must advise on draft codes of practice that the minister intends publishing for comment in terms of Section 9.5. Nothing else, 9.5. And then E, the Council must, if requested to do so, advise on draft transformation charters. Now, a transformation charter is...
If requested to do so.
Yes, my lady, if requested to do so. Now, the minister may request, when a draft or a transformation charter is drafted, give me your views, advise me. And why is that? Because that's the industry. And that argument has been made. I'm not going to go, it's going to go around in circles, but I'm just honing in to the point that this is not discretion. If there's a discretion, it's found in 5E. It's not found in 5A, B, or C. Now, why is it the Council's responsibility to A, advise on BEE, and B, to review the process in achieving black economic empowerment? Why is it so? Because they know they're the subject matter experts and they are in a better position, or in the best position even, to advise on draft codes before they are published. And that's an important distinction, which the minister intends publishing for comment. So that thing has now been developed to an extent. Now you are going to ask comments from business in the industry. And what do you get? 160 comments, of which about 75% is opposed to it. If this was done, there may have been the other way around. There may have been 75% who supported it because they then understood what it's all about, these weightings and targets and all the rest. It could have been done in another fashion. There could have been a better consultative process with the bars, for example. Mr. Patel's affidavit, which I've referred to in my opening address, clearly says, I think a reference to K-Bar and the Joburg Society of Advocates, he said, but their comments and concerns and queries weren't properly addressed or at all. So, let's just speak hypothetically. This advisory council advised, no, Minister Patel or Mr. Taude, I don't think you should publish this for comment. There are issues in this code. You change what you shouldn't change. You take out the element, I was using in the first code, it was still there, the socio-economic issue was taken out and all the rest, but if it was taken out at that time, they could have advised to say, no, put it back. It was eventually taken out. But that could have been resolved if the Act's provisions were followed. Now it's easy for the minister in argument now to say, and I'm quoting, if you don't like it, go somewhere else. If you don't want to comply with the code, then leave it. It's not as simple as that.
Be legally.
Yes, my lady.
In terms of the rule of law.
Yes, let's look at let's leave the emotions. Let's leave that aside for a moment. What will you get if, let's say, this code is not reviewed or declared constitutionally invalid? Where would that leave the profession? Well, 95% of the attorney's profession apparently doesn't need to comply. Where would it leave the advocate's profession? They would still be the pawns being moved around by the rooks and the kings and the queens, being the attorney's profession. And it's in the code and in the statement to say they are the lever. The advocates are the lever to attain what the code is setting out to do. Now, advocates under 3 million rand don't need to comply. Black advocates get a level 1, and I think white advocates get a level 4. I think there are 9 levels. Get to levels at the moment, there's just one issue of that I just shortly need to address. But advocates are impacted. How many of them? How many advocates earn above the 3 million rand turnover threshold? We don't know. Because that data, I looked, I couldn't find it in the record. That data didn't serve before the minister when he made up his mind. It's easy to now, after the fact, for the bars or a bar or the GCB to come and say, yeah, but we need this. Yes, we need this, but let's do it properly. Let's base it on empirical evidence, on data. That was not before, Minister Tau, and I invite you to peruse the record, where this was debated or even taken into account. What about the advocate's profession? We only have skills development. That is the measurement. The attorneys have a number of measurements. We are left as advocates, as the advocate's profession, with only skills development. And it's impossible, and Mr. Arends for the GCB made the point, the most affected by this code would be the advocates. And he further made the point. He joined the AFT because the Constitution was non-sexist, non-racial. And he said, for instance, it includes white female advocates. But now they excluded from the working of this very code. And even Ms. Baloy SC, she then was, when she was the chair of the Joburg Society in 2021, I believe, if my memory serves me correctly. Get the reference now. I just want to quickly... I know that the B-BBEE Act it defines black legal practitioners. I know that. We all know that. But you must look at the effect and the rationality of that code. Now, the GCB says the talking is over, the proof of the pudding is in the eating. But was said then by Ms. Baloy SC. That is case lines 082697, 15 March 2021, slap bang in the middle of COVID. One of the issues raised in footnote 7 on that page, now I just want to quote it briefly. Not saying this is correct or wrong, but this is a concern of the Joburg Bar from Ms. Poloisi. Sign it off. The LSC draft doesn't distinguish between male and female white advocates. As such, it's fatally defective. Evidently, the threshold for white female advocates should be higher. It can hardly be suggested that the playing fields are level. Now, I invite you, my ladies, to look at the final legal sector code and the weightings attached to the skills development. That's the sole component where advocates can comply. And a lady, female, can never attain 50%. You can look at it. I'm not going to argue it. It's all there. I don't want to make this a political thing, but it's about the rationality and the argument of the GCB and the Johannesburg Bar saying what they said, and here we are. So was that taken into account? Apparently not. Now there are many other examples. Order the Pretoria Bar made submissions, KZN Bar made submissions. It's all there. Not going to repeat that. But let me just close in on the point of section 5. If we look at, let's go there. Even if you look at statement 008, why is the 003 money?
No, 007.
007, 008, 003. Malady 01-225, that's the code. This is about the role of sector charter councils. I know this is about the code, but let's look at the importance of the Ministerial Advisory Council. Paragraph 6, and then it says, it sets out main responsibilities of the sector charter councils, and then to compile reports on the status of BEE, and then 6.4.3. The sector charter council to share information with sector members, approved accreditation agencies, B-BBEE Commission, B-BBEE Presidential Advisory Council, the line minister and lister of DTIC.
Did you refer to?
Yes. Why is it important for the sector charter councils, plural, to share information with the advisory council? Because they must advise on policy. They know. So they can say, okay, in that council, the following happened. I'm advising you now that this thing is wrong or it's right or amended. It goes further. 6.5, the importance of the advisory council. The sector charter councils should report to the line ministry, the Minister of Trade and Industry, and to the advisory council on progress made by the sector, subject to the relevant code. Report. So it doesn't say must, but you should. And why? The reason is obvious. Let me then turn briefly to the second last issue, my lady. I'm really going to attempt to be brief. You know, it's Friday, and I always this joke that council in Pretoria doesn't work after 2. So here it's been spilling over to Joburg these days across the XK as well, but yeah. All right, section 9 and not. There's a bit of confusion here. Mr. Nalani was asked by the bench, now, what is it 12 or is it 9? Now, he didn't accept that it's 9. Section 12 is not at the heart of this matter, although it's also relevant, but it's not at the heart of this. Section 12 concerns naturally transformation charters, and Section 9 evolves around the Code of Good Practice. The minister's functions are not the same, the requirements are also not the same. Now, by relying the respondents, as they did, on sector engagement, stakeholder support, and the phrase the legal sector's own code, this may have some relevance to the Transformation Charter, where I referenced 5E, may, if requested to, but it doesn't answer the requirements for a binding code of practice issued under Section 9. That code is issued with consequences under the B-BBEE Act. There are distinct and identified consequences, including consequences for organs of state public entities, impacting on procurement decisions, briefing patterns, and the legal services market in general. And this is not a technical point. It goes to the heart of the decision maker's appreciation of his or her statutory task. If the minister's case is advanced on the footing that the instrument is a Section 12 transformation charter, when the Gazette specifically states it's a Section 9 code, then the court can really not be satisfied that the minister applied his mind to the correct inquiry. And this may explain certainly some of the respondents' difficulty. There may have been a bit of an affair here. If we look at the first respondent, I request your ladyships to have to the first respondent's distinct, separately filed answering affidavit in the solidarity matter. It's much shorter than the one in the Nice or Norton Rose matter. And that would explain a lot of the difficulties, including the following, and I'm going to close with this. When asked, well, that is a thread that runs really through all of the first three respondents' affidavits. When asked, now, why did you adopt it in the fashion that you did and publish it? And it was said they didn't adopt it. It wasn't the minister, steering committee. He just had to publish it. And I think Norton Rose or the NICE also used the wording in their application, a rubber stamp, the same as used in their affidavits. It's just a rubber stamp, it appears. But if it's not, show us the record. And tellingly, after the record was received in this matter, before the supplementary affidavits were prepared by both parties, now no Norton Rose has written such a letter, it's in the record. Solidarity also wrote a letter in the same vein saying, the record is clearly deficient. We beg you to send us the complete record, at least the following, and it was listed.
That was never addressed by any of the respondents.
No, it wasn't, my lady, but it's annexed to the supplementary affidavit of solidarity. They were requested to finish the complete record or at least the following. Listed. Deliberations, minutes, show us. Well, I don't want to say what the parties have received. Yeah, but there was no response, put it that way. No response. No, not saying, okay, I tell you what, let's just grant an indulgence here, or just have a bit of a round table and say, well, give us another 60 days. Let's talk about the condemnation issues, but let's do this.
It stated that no one has records.
Thank you, my lady. And that is the explanation. But it wasn't given in reply to the letters. It was just stated. So who has it? Well, the minister. Isn't he the custodian? And if not, we have the steering committee and the technical committee. And I just want to go to the issue of the technical committee is raised in solidarity submissions. That was also not properly constituted because there's no provision for that in the Act. The council must do that, and the ministers. There's no such thing as a technical committee, and to make matters worse, it was explained that the technical committee was more involved with drafting and research, whilst the other respondent says, no, they actually looked at the comments and responded to that. So we don't know really who did what. And the last point on that committee issue is the technical committee largely composed of the steering committee members. That is really an issue. And that is why the advice, at least, of the advisory committee, if not before the publishing, why can't you get it at a later stage? But it's just totally absent. So the record, as it stands, is what your ladyship should assess this matter on. Nothing more and nothing less. My lady, the issue of costs, BioWatch. I see that the GCB, I heard Mr. Arendts saying that they want costs. I don't know for what. They didn't really say. I may have missed it. Then I apologize. But you wanted costs. I don't know why. We're not going to ask for costs against the GCB, but I hear they want costs. With regards to the cost issue, BioWatch principal supply and costs of 2 council on scale C. unless there are any further questions from the bench, that is my story on a Friday afternoon, 2:01.
Thank you. Yes, Ms. Mongani.
If I may add to the spectacle, my learned senior, Mr. Bum, says that there is nothing from the respondents with regards to justice and equity. And of course, my learned senior, Mr. Nkaitobi, says that it is only the minister who can speak to justice and equity. It is not correct. Sauna's affidavit at 022346. 022346, we dealt with the issue of justice and equitable remedy, but in any event, we deny that in terms of Section 172, read with 8 of it, is only the DTI minister that can speak to justice and equity, because the court there, the only thing that limits the court is justice and equity. That includes the effect on the respondents and women in particular for my client. May it please.
Thank you. I think I speak not only on behalf of myself, but on behalf of my two sisters. All the arguments or submissions that were made is very valuable. The court needs to consider. The court cannot close its mind to one aspect of the law. There were different aspects raised by different respondents. Importance is that one should have regard to each and it, and then the court will decide which are relevant to what we need to decide. The heads of argument, I know parties worked very hard, long hours. If we look at the record, the court record. So we want to thank you. We are going to reserve judgment. Court will adjourn.